Welcome to Leveraging Inspiration, the Inspired Patent Podcast. Your employees are using AI, whether or not you know it. Today, we will discuss the risks and consequences. In this episode, we're talking about legal updates to AI and copyright. I'm Wayne Carroll, your host, here to share valuable insights, stories, and strategies for succeeding in intellectual property. Let's dive into the game of IP and learn how to win. This podcast is strictly educational and informational. It does not constitute legal advice, and listening to it does not establish an attorney-client relationship. Your employees are using AI. According to a February 2023 survey by Fishbowl, 43% of professionals are using ChatGPT at work. So of those 43%, we're going to take that as 100% of those who are using it. Of that 100%, about 70% in this survey say their boss doesn't know. This is something that you will want to find out about. What are the risks? Should you institute a policy that AI is not to be used in your company? Can you use it and have policies around it rather than letting it run amok in your company? AI, if artificial intelligence is found to infringe copyright or have other legal risks, then your company's use of AI could bring liability. So let's discuss some cases around artificial intelligence that are currently pending. Getty Images filed a lawsuit in February of this year, 2023. Getty is saying that it is copyright infringement for Stability AI, an image generating artificial intelligence, to have looked at all their images and learned from them. What's interesting is they have labels on each of their images. And that's extremely helpful in training the artificial intelligence, because it says the labels say basically this is what's in this image. And then the artificial intelligence looks at that image and gets a better understanding. Since they have millions of images, they say they have over 12 million images, and they say they've been scraped in order to generate the basis for their artificial intelligence to create photos. Now, what's interesting is, since they've been looking at these Getty Images photos so much, the AI, as it trains of what is important in a photo, in some of them, it's decided that the watermark that Getty Images put into the photo is important. So when it produced some of its pictures, the watermark or a version of the watermark showed up on images that were generated by the Stability AI. And this could also bring up trademark issues. There's a doctrine in trademark saying, if you're using my trademark, and my trademark is famous, and Getty Images can probably pull that off to say Getty Images has a famous trademark. They can say, if you're using it in a way that throws bad light on my company, then that's a form of trademark infringement. So Stability AI has an interesting case on their hands. We'll see how it comes out. If copyright infringement is found on 12 million images, the damages are likely to be in the tens of billions if they find copyright infringement on every single one of 12 million images. So that's the Getty case. And another case is a class action lawsuit, also against Stability AI, but including Midjourney and DeviantArt. It was also filed this year, 2023, in January. Also, again, it's a group of artists that are bringing a class action lawsuit, and they're saying that by the AI scraping billions of copyrighted images of all these different artists, they've been doing that without their consent. Now, one of the things that's been brought up in a motion to dismiss is that they're claiming the AI does not actually store the images, but stores information that it learns about the images. So that's going to be interesting. A lot of people are saying questions like, well, if I studied under somebody, or I studied all of somebody's works or art, would my art, because it's been influenced by theirs, would it be infringing or not? So that's what some people are comparing it to. Copyright infringement requires that either you show copying of the work, which is often very difficult to say, yes, this is a copy, here's where they had a copy, and they made this copy off of it. And so usually they're comparing circumstantial evidence to prove that there was access and that there's substantial similarity. So here's where the issues can come up. If your company says, let's not pay Getty Images or whoever else you've been paying for images for your website, we're going to pay an AI much less money to generate the images and just tell it what we want and we get exactly what we want. If that looks highly similar to one of the copyrights or copyrighted images that it learned from, there's a chance your company could face copyright infringement, a cease and desist letter. So that's one of the other issues going on here. There's another case with GitHub. There's somebody suing GitHub, Microsoft, OpenAI, and others, and they're saying GitHub says, others can view your code when you upload it to GitHub. There's different licenses and attribution and such that are attached to those uploads in that rule. Well, they're saying that the AI learned their code, but isn't following the rules that are in GitHub. Sometimes they're not removing identifying information from that code, and including the content management information, which is part of Digital Millennium Copyright Act, to make sure you don't have liability for copyright infringement of others. So it's interesting question, since AI is so new, it's probably making a lot of mistakes legally. The question is, are you willing to take those risks with the AI, and how serious are these risks? Part of it depends on what is it you're doing with the AI, and are you proofreading carefully after the AI generates what it does, whether it's images or words or code. There's a lot of programmers who are finding that they enjoy programming a lot more when they are doing more of the high level, how everything kind of goes together, and they are letting the AI do kind of the grunt work of hashing out the code, making sure the inputs are, transformed into the outputs for each module. And so the programmers can do much more high-level planning and directing. That kind of goes into a question of what is copyrightable. So if you're creating things that you want to get copyrights on, the Copyright Office has said you have to be human to get a copyright in the United States. If you're not, then you don't get a copyright. Now the question is, if there is content that's combined. So there's a case, and there's a long letter that has been published by the Copyright Office regarding a comic. Basically, what they've done is the words of the comic, they're really popular. You read through and you look at the images, and it kind of enhances your experience of reading. So that's still a very popular way of people reading. What they do is they applied for a copyright where all of the images were created by an AI based on the text of the comic, but they arranged those in the way they wanted, put the words where they wanted. And what the Copyright Office has said is the text is copyrightable and the arrangement of the images is copyrightable, but the images themselves, since they were generated by an AI, are not copyrightable. So understanding that it might be worth, being able to generate things much faster, using the AI and understanding that, okay, people can copy your individual images and you can't do anything about that. But if somebody copies the whole comic strip, that's comic book, whatever form it's in, you're still going to be able to go after them based on that. So there's one other case that is kind of informative. Google, and this is a case that's completed from 2015. A group of authors, the Authors Guild, sued Google because what Google was doing was they were going to libraries and they were scanning books so that they could then give people snippets of the books and make it available for them to purchase. People could search and find what they were looking for in books much easier. The court decided that that was a transformative use, that they were transforming it enough that they didn't have to take a license from every author in every book, because they didn't ask anyone's permission to do that. They just went ahead and did it. You'll want to stay up to date with copyright developments. Subscribe to this blog. Subscribe to this podcast, as that's a great way to stay up to date. And when major events happen that may change things, and if there are specific concerns, reach out to me and we can have a consultation. Our first consultation is free. So I'm Wayne Carroll, and this is Leveraging Inspiration. You've been listening to Leveraging Inspiration, the Inspired Patent Podcast. We are live on ibgr.network at 3 p.m. Eastern Time every Friday. You can also find us anywhere you find your favorite podcasts. Our show today is sponsored by Inspired Idea Solutions Law Firm, an IP boutique law firm where we put your strategy first, use a proven process for success, and guarantee zero hidden fees. You can find us on the web at z3ip.com. That is Z as in zebra, the number 3, and IP as in intellectual property.com.